Welcome back to this final segment in this law session as it relates to the development of the common law. We have basically charted the meaning of law right through to just before the break, looking at judge-made laws, or rather looking at case law and looking at judicial decisions and case law as being a definition of when we look at the common law. So you have statute law, it could be common law as well for case law. But there is a wider meaning to common law, as I've intimated earlier. When you look at the wider meaning of the common law, it is where it is used to describe a group of related legal systems. So when you look at the English legal system and the format, the procedure, the way it works, this has by and large been exported around the world during the colonial period. We see, for example, that this type of legal system operates, for example, in the USA, in Jamaica, in most of the Commonwealth countries. They are all based on English common law, although they may of course mix in local customary laws or some religious-based laws or other influences. Now, each country has its unique characteristics, and what makes these different is the jurisdiction or the way that they approach their laws based on, for example, what the local climate calls for. Now, when we look at the US system, it was, of course, said in Van Ness and Packard that the common law of England is not taken in all respects to be that of America. Our ancestors brought with them, in general, principles and claimed it as their birthright, but they brought it with them and adopted only that portion which was applicable to their situation. So what we have seen is that this common law tradition has by and large been added to and refined in other jurisdictions. Now, when you look at the legal systems of continental European countries, which were also exported around the world, this gave rise to civil law systems. Now, the most influential of these has been that of France, because by producing the Code Civil, Napoleon gave to France the first modern European legal system. So in practice, each jurisdiction may mix their similar legal tradition with local customary or some other religious traditions. Now, there are several ways of categorizing the law, and these include, of course, the common law and the civil law, as we've mentioned. So the difference between what obtains in England versus France. The common law and equity, again, which we have looked at earlier. You may consider public law and private law. And public law looks at those matters to deal with the state, private laws against individuals, and also the distinction civil law and criminal law. Well, within the English legal system, it is often useful to consider the division between these various types of breakdowns. So when you look at, for example, civil law and criminal law, it looks at how persons deal with each other versus the criminal law, where the state deals with individuals in a criminal context. Now, the term civil law is used in this context to do with criminal and civil is part of the private law, and it is about the relationship between private individuals. Now, within this division, there are a number of specialist areas. So the law of contract, the law of tort, the law of property are all civil law matters. The criminal law is part of the public law and is concerned with conduct which the state regulates. Now, you may have a set of facts which give rise to both a criminal law claim and a civil law claim. Now, for those of you, for example, who remember the O.J. Simpson trial, for example, it meant that there was a criminal law case, which was that there was allegedly a murder, but there was also the civil law claim as well, because the same actions can give rise to criminal as well as civil liability. So when you look at the criminal law, civil law, and public law type frameworks, let's consider them for a moment. Criminal law looks at the power of the state to punish persons, and by and large, this is where it regulates behavior. And certainly, if there is any wrongful harm, then it is up to the state to bring the action. When you look at the civil law, again, outside of using it as a contrast to the common law, it is where persons can bring private law actions as against each other. And certainly when you look at public law, this is where it can be used in a loose form to refer to various things. When you look at constitutional administrative law, for example, or public law is used, for example, where the state is involved. So you have public family law situations where you're looking at local authority matters. Or when you look at immigration law, again, that is a public law matter. You may also draw a distinction between substantive law and procedural law. With substantive law, you're looking at the rules which are applicable to the merits of a dispute. You're looking at what is called black letter law. So when you look at contract, the definition of an offer is a willingness to be bound once it is accepted by the offeree. That is substantive law. So you get substantive law to do with contract, tort, criminal, and the like. When you look at rules of procedure, these are rules which govern the manner in which a dispute is resolved. For example, when you look at the civil procedure rules, for example, it does provide for how matters are to be dealt with in the civil court in England and Wales. Well, what about the role of the judges? Well, historically, we see that the judges are the ones who have had to adjudicate on matters before them, and it is by virtue of this adjudication that they have taken on board other types of laws, for example, EU law. They will take on board the case law, the statutes, and the like. Now, when you look at the legal doctrine which has built up, the common law has been described as inductive and empirical in nature. So it proceeds at first in an incremental way, laying down its rules on a case-by-case basis, and it is only after you have any sort of great degree of precedence that you then see some kind of effecting of those precedents in the laws or the cases which subsequently come. When you look in contrast, we see that the civil law tradition emphasizes a code. So it proceeds on the basis of an exhaustive code which tells you what is right, what is wrong, what you should do, what you shouldn't do. One other type of comparison you have as well is adversarial versus inquisitorial. Now, the English legal system is adversarial in nature as opposed to inquisitorial in nature. So in the civil law systems, we see a more inquisitorial approach being taken. So with the adversarial, it's about going into court, one lawyer pitting his wits against the other. With the inquisitorial, it looks to try and find the right balance to find out what is wrong. They need to go through and find out from the parties what exactly is the dispute about. So you get a more interventionist approach from judges in the kind of inquisitorial framework. What we have seen with, say, the civil procedure rules, for example, is this requirement for the judges to get more involved and interventionist and taking a more inquisitorial approach when it comes to matters like that. So by and large, when you look at the general approach in the common law, judges tend to take a backseat somewhat when you look at how the proceedings are driven. The principles and the case law in the end is what stands for the law. But when you look at how proceedings in court are dealt with, you tend to find that the lawyers drive it in the common law jurisdiction. However, when you look at the civil law jurisdiction, it seeks more to delve in depth, and it gives the judges more of a right to examine and to conduct to take an investigative approach, to conduct some sort of investigation. We do see, of course, that there are problems with the adversarial nature, because when you look at it, it sometimes means that the parties are holding on to a point that they're holding on to simply because they are fighting their client's corner, as opposed to assisting the court to doing what is right. And that, by its very nature, may of course cause a problem. Now, with the common law tradition, we see that there have been changes. There's been a vast evolution. We've seen where the courts have made decisions which have been important. We've seen statutes, for example, which have come within the common law tradition, which have a degree of importance, like the Human Rights Act, for example. What I want you to do is to digest the whole background to the common law tradition, and certainly I want you to continue within the series to join me in looking at things like precedent, statutory interpretation, and how the case-by-case development has meant that certain principles of the common law firmly have their roots within the cases decided by judges. That, of course, brings us to the end of this law session, and certainly ask you to join me for the others in the series.